Well, good. That's great. I think this is a really good actually way to start because you can see already here you have lots of different aspects to the question, right? So you have questions of origins, you have questions of stability, you have questions of writing the constitution and then upkeeping it for later generations over the decades. Then you have questions of what values does it contain: justice, equity, justability, conflict resolution. And of course, what it does, it provides a kind of institutional safeguard, and it is intimately connected to freedom and rights. So I'm going to talk about the constitutional dimension of basic income and the constitutional dimension of welfare state governance more broadly. So what this means is I'll be looking at the intersection of constitutional studies or constitutional economics, constitutional legal studies, constitutional philosophy, and the discussion around basic income. And to do that, I'm going to have to go a bit back. I'm going to have to go a bit further back than the contemporary discourse. I'm going to have to go back to the roots of constitutional thinking. And I'm going to have to explain to you, to give you the tools to understand where constitutional thinking comes from, what it has done over the decades and centuries, and why it matters for people today. And why, in particular, I believe you in Freiburg are in a very good position to contribute to this, because you are here at one of the most important centers in the German-speaking world, of course, at least, of constitutional thinking with the Otto School and the important contributions of those scholars to constitutional thinking. But outside of the Otto School, there are many different schools of constitutional thinking, and all of those can be valuable to you in different aspects of your research. And I believe that the constitutional dimension has been neglected a little bit in the basic income discourse, and that is a mistake that should be corrected. Because the constitutional dimension of basic income discourse matters for a lot. It matters for all these issues that we've outlined here. It matters perhaps for how do we achieve stability, how do we get institutional safeguards in place, and how do we tie the basic income to questions around justice, equity, freedom, property rights, and so on. And since the Constitution is such an important part of all those debates, if we want to tie basic income to those questions, I believe we must tie it to constitutional questions as well. Okay, and the constitutional political economy of basic income is also intimately tied with the social contract theory. So social contract theory historically and theoretically and practically is closely related to constitutional thinking. Not all constitutional questions are social contract questions, and not all constitutional theories are social contract theories, but especially after the Enlightenment and the revolutions in France and America and elsewhere, the social contract theory has been at the heart of constitutional discourse, and I will explain what that means. Very good. So let's first think about the intuitive link between basic income and constitution. Well, this may be a bit of a rhetorical trick, but the word basic income has the word basic in it. So what does the word basic mean? Well, in German, you use the word Grund, right? You have the idea of Grundeinkommen. Well, what is basic about basic income is not just, I would argue, that it is set at a basic level, but it's also that it is at the foundation of things. So when you have a basic income, you have something that is foundational. And you have to think of basic income as something foundational. At least I believe this is what you should do. Some people don't do that, and I think they do so at their own peril. Basic income is basic, it's foundational. It doesn't mean that it needs to be accepted simply because it has the word basic in the title, but it means that if you think about basic income, you're thinking of something that potentially links to the basic structures of society. So John Rawls, for example, one of the leading social contract theorists, talks about the basic structure. Well, the basic structure could theoretically be linked to issues like basic income and also other welfare state structures that are on that basic level. Constitution itself is also sometimes called like the foundation or the basic level of the law and the legal system. So in that sense, For example, in the German case, where you have this quasi-constitution called the Grundgesetz, you already have the same word there, Grundgesetz. And then you can think about, well, maybe the Grundgesetz could be linked to Grundeinkommen and what the different meanings of Grund in those terms mean. So basic income and basic law, let's call it basic law, the constitutional law, are somehow related to the foundations of social order and the basic structure of society. Also, the word constitution derives from the Latin word to establish or to set up. So constituire means to set up or to establish or fix in place. So here we already have the idea of stability and safeguards. So the constitution is something that is fixed and established. And in fact, the word state has the same etymological origin as the word constitution. Constitution, stitutio, and state come from the same word. State also refers to stability, establishment of something fixed. So the constitution could be understood as that part of statescraft, that part of the basic structure of the state, which is the most foundational, that establishes the fixity of the legal structure and of the rights of citizens within the state. Okay. The basic law or the constitution is especially linked to questions of human rights, questions of property rights, and also in some cases to a much more pluralistic sense of citizens' obligations and rights towards each other. And in fact, one of the things I want to emphasize today is the pluralistic understanding of constitutions. If you go through the world and if you look at the differences between, say, the German, the United States, the Finnish, the Latin American, the Asian, the African constitutions, you will see that there are big differences in how those constitutions are written, what items they contain, and what kind of rights and duties they grant to citizens. Some countries rely more on their constitutions and see the constitution as very, very important indeed, and they have very strong legal safeguards in place, for example, through the judicial system, through constitutional courts and the court system more broadly, to safeguard constitutional rights. In other countries, the constitution is more of a nominal rhetorical document that people sometimes refer to, but don't really take all that seriously. And most of the laws are really done in the parliament, regardless of what the constitution says. So this again sort of anticipates what we're going to talk about in the second session, which is how do you actually maintain the stability and the reliability, the resilience and robustness of a constitutional structure over time. So the plurality of constitutions also means that how basic income fits into constitutions will depend on what kind of a constitution you have and what kind of a tradition of interpretation of the constitution you have. So it's important to look at the existing constitutions, what they say about people's rights, in particular in relation to social security, to material security and such, and look at how basic income fits into that existing discourse and how perhaps basic income can be added onto or fitted into these existing structures. Somebody already mentioned Greece, and indeed, the constitutional discourse really, at least in the Western world, and this could be a Western perspective, but it's not just a Western perspective, because the Western thinking on the constitution, it has heavily influenced the rest of the world. And indeed, a lot of that comes from the Greek and Roman authors. I won't go through a long history of them, but I will just mention a few names here. So Pericles was important as an Athenian lawmaker, and the Periclean constitution started from the premise that people are equal to each other. And in fact, this was a very radical statement at the time, and it was much debated. Many people did not like this idea because there was an understanding that there are natural hierarchies in the world, and the law should reflect natural hierarchies. To be fair, even in Periclean Athens, there were still hierarchies, there was slavery, and there was everything else. But the idea was first put into law that there is some kind of an arithmetic, as they put it, arithmetical equality between people, so that people are equal citizens who must obey the same laws and also have equal rights in relation to each other. This idea, of course, was refined and refined over the centuries and really picked up during the Renaissance era and the Enlightenment, when most of sort of modern discourse around constitutional law was reestablished. But still keeping to the Greeks for a moment, it's important, for example, to start from the debate between Plato and Aristotle on this issue. Plato argued that good statecraft must involve strong, wise leadership by a philosopher king, someone who has both the capacity and the desire to rule over the social order, to set up good laws and to enforce them. Because a philosopher king is not bound by a constitution, at least in early Plato. Later on, he added some sort of slight constitutional aspects of this, but Plato largely thought that the constitution or a system of written laws is mostly an impediment to good rule, because good rule requires that there is a wise, strong leader who knows how to rule and is not bound by established practice or previous experience or even the will of the people, certainly not the will of the people, because ordinary people are not capable of rule according to Plato. And so Plato's anti-democratic sentiment was also reflected in the anti-constitutional sentiment. So Plato argued that written laws are like, we become enslaved to written laws, and that they become a hindrance to good governance. This debate is still with us today in contemporary discourse, where some people argue that constitutional rules, sort of blind obedience to constitutional rules, can act as a hindrance to good governance because we are bound by something that some people wrote 50 years ago, 200 years ago, and this prevents the society from responding to new challenges or the new demands of the people. And so there's always this challenge to constitutional thinking that it's too fixed in the past, too fixed in established structures, and it's not flexible enough, it's not adaptable enough. But at the same time, you have Aristotle, who was Plato's student, who argued that on the contrary, even though Aristotle was not a fan of democracy either, but he did believe in some form of constitutional legal thinking, where he believed that as a matter of fact, what is important for good governance is, yes, you should have good rulers, but good rulers too need to be bound by certain basic rules. And in fact, what you want is a system of rules that secures people kind of stability over time, and also the capacity to have their rights protected over time, because you have the tendency of kings to become tyrants, which was a big debate in the ancient world, and you have a tendency of non-written constitutions to be overturned all the time. So in order to have some stability, some capacity of structure over time, you need written rules, and this became the basis of what today is called the rule of law thinking. So rule by law, not by men. Plato believed in the rule by men, not by laws. Aristotle believed in the rule by laws, not by men. So let me just quote Aristotle here. Aristotle wrote in Politics, a very influential book indeed, that it is more trustworthy to have the law rule than any one of the citizens. And it is even better to have even if we have certain people who rule, they should be selected as guardians of the laws and assistants of the laws, not as the supreme leader above the laws. So later on, this idea influenced Enlightenment thinking, and for example, in the Constitution of Massachusetts in 1780 in the United States, people said that, so this was written by John Adams and a few others, that we should have a government of laws, not of men. The rule of law is supposed to act as a check on arbitrary, tyrannical, and coercive government, and to also support the equality between citizens and also their basic rights and liberties. Okay. So the most important phase in constitutional thinking was the Enlightenment era and the revolutions in social contract thinking at that time. There were some intimations of this already earlier. For example, in the common law tradition of the United Kingdom, you have the Magna Carta already in the Middle Ages, late Middle Ages, which tied the king to respecting the rights of the barons and the upper classes. It was not a democratic constitution, but it was kind of a quasi-constitution between the king and the upper classes. So the upper classes had some autonomy and rights and equality from the arbitrary rule of the kings. But really only in the 1600s and 1700s, you have people in the UK, in Europe, France, and later on in the United States, arguing that no, we should actually extend this thinking to the whole society and to really democratize or republicanize, as they also sometimes put it, the society by making the social contract clear. And what they meant by the social contract was precisely that the authorship of the laws is ultimately in the hands of the people. The people are the sovereign rulers of the society who deputize temporary rulers, temporary governments, indeed even kings, which was a very radical idea at the time. So as opposed to the divine right of kings, which was a very much dominant view at the time, they argued that kings derive their justification, if they have any, from the consent of the people. So that's why you have phrases like "we the people" being used. So if you look at the Constitution of the United States, for example, in 1787 to 1789, it starts with the phrase "we the people." Now, this is unheard of. Similar phrases are found in the French Declaration of Rights around the same time, and in other constitutional reforms in that time and centuries and decades to come. The theorists who gave birth to this were John Locke in the UK, who argued that the sovereignty of the state is based on a contract between the citizens and the rulers, based on the respecting of the rights of the citizens, which he argued were already naturally given to all citizens as free and equal creations of God. And in fact, the equality of people before the law was predated and presaged by the equality of people before God. So since God created people equal, they argued, so also the state must respect this basic equality between citizens. Later on, the theological dimension, the dimension of holiness also, which was mentioned in the discussion earlier, it always remained an important part of constitutional thinking. But of course, you can have secular constitutions, and most constitutions today in the Western world anyway are secularized. They argue that equality of people is naturally given not necessarily God-given, but whether you say God-given or naturally given, you argue that there is some natural equality between people or some natural freedom and natural rights that people have, which then people coming together to set up a society or to pledge their allegiance or obedience to the laws, then use their natural rights to make a contract between themselves or between themselves and the government to abide by the laws, but to abide by the laws only to the extent that the government respects the Constitution, which is understood as the written manifestation of the hypothetical social contract between the people as free citizens, free and equal citizens. So this language of free and equal is everywhere around the time in the constitutions. So yeah, you have people like Montesquieu, James Madison, John Locke, Spinoza, Rousseau, who all put their different spins on the social contract foundations of constitutional thinking, but they all emphasize the equal liberty and equal rights of citizens as the foundation of the constitutional order. Very good. Let me quote a couple of more contemporary thinkers who represent the sort of contemporary manifestation of this idea. So here's, for example, the philosopher John Gray, who argues that the foundation of this social contract vision is that we protect our interests, that is, we the people, if you will, protect our interests and promote our welfare as best as we can, not by treating the rules of justice as at any moment defeasible by reference to private or public welfare, by saying, okay, at this moment, the constitutional rights are a hindrance to what we can achieve, but precisely by treating them as almost invulnerable to overthrow or abridgment. So there is a kind of almost blind obedience which can be justified according to people like Gray and David Hume, who he references, because only by this kind of long-term thinking, long-term fixity and establishment of the basic structure of the basic rights do you get good outcomes in the long run. If you try to make kind of prudential judgment, discretionary intervention at every moment, you might make things better at some point, but you also undermine the stability of the order and you undermine the fundamental equality of citizens and the right structure that protects their interest in the long run. So this is the argument anyway. So this comes with the recognition that there are downsides to constitutional obedience. And the necessary downside is that we cannot have laws always tailored, or the basic structure cannot be always tailored to each particular need or circumstance, but it needs to be rather inflexible over the long run. Doesn't mean that you cannot build in some level of flexibility, and then especially in session 2, we can talk more about what that flexibility can mean and how it relates to resilience and robustness and adaptation and these kind of questions, but that there has to be some acceptance that we cannot achieve everything we want with the basic structure of the laws, and we just have to hope and build the structure such that in the long run, most people get more benefits out of it than they lose with it. Therefore, from this kind of Lockean idea that we should oppose absolute, arbitrary, unlimited, and unlimitable power of the state by guaranteeing some basic rights, the argument follows that, as Hume put it, public welfare requires that property and rights should be regulated by general inflexible rules, and those such rules are adopted as at best serve public welfare, it is impossible for those rules to prevent all hardships in all cases, or to only have beneficial consequences in every case. So this is the kind of the tension we have. We need constitutional rules, but we also need to build them to be maximally beneficial for public welfare, while also preventing unnecessary hardship, with the recognition that we cannot prevent all hardship as long as we are ruled by laws and not by men. And of course, the idea is that if we were to move towards the kind of Platonic philosopher king model, or what the German philosopher Carl Schmitt, for example, called the state of exception model, where the heart of politics is the capacity to overwrite and overrule the rules, then you might get good benefits in some cases, but you will also threaten the move towards tyranny and threaten the erosion of basic rights, and therefore also prevent long-term social welfare from manifesting. Okay, so this is kind of an overview of what the constitutional structure is, and why its sort of Enlightenment foundations are heavily focused on issues of rules versus discretion, and on rights versus privileges, and on kind of fixity of structure versus flexibility of structure. Let me give you an, so in this lecture, I am not going to go through the James Buchanan paper in detail. In fact, I will only very briefly summarize its arguments with the sort of expectation that most of you have read it. So there's no need for me to go through the paper in detail. And before I even do that, I want to take the German case, because we are in Germany, if you haven't noticed, and Germany, and in particular Freiburg, as I mentioned already earlier, is a very, very important branch of constitutional thinking. So first of all, I think it's interesting to look at sort of the complicated constitutional history of Germany. So I'm not going to go through the whole history, but you know, in 1848 and 49, there's a year of revolution, and there was a big movement in Germany towards securing those kind of same liberal egalitarian rights that had already been secured by the French Constitution to some extent, and despite the Napoleonic interludes, and by the American Revolution. And so the Germans wanted to create a constitution, and out of those protests and movements came the Frankfurt Constitution in 1849, which was first secured kind of the German basic rights and liberties. And then these rights were in different ways modified when the unification of Germany happened in 67 and 71, and the sort of Bismarckian constitution took over some of the rights from the 1848-49 constitutional movement. And so the Bismarckian constitution then was the foundation really until the Weimar Constitution. And the Weimar Constitution is a bit, you know, notorious in history for failing to prevent the rise of fascism in Germany. But it's a bit unfair to it because, yes, it did have some flaws, but it also was a very important liberal egalitarian document. And in fact, the German Constitution, or Grundgesetz today, which I will get to in a moment, picks up many of the elements of the Weimar Constitution, while also modifying some aspects of it that were not suitable for modern times. So the Weimar Constitution, in fact, was officially in place all the way until the end of the Second World War. But in fact, in 1933, the fascists used the emergency clause in the Constitution to overrule the basic rights and liberties of German citizens. And in fact, it's very, very important to realize that just because you have a constitution doesn't mean that those rights are secured if people do not respect the constitution, and if the constitution doesn't has these kind of emergency clauses or exception clauses, which people like Carl Schmitt, who was a fan of fascism, really liked, because they give more power to the ruler. And Plato would have also loved this. I mean, I don't think Plato would have liked Hitler, but he would have liked a constitution that allows emergency measures to be taken. And in fact, even the modern constitution allows some emergency measures to be taken, but the question is how much discretionary emergency power should be granted by the constitution. And clearly the Weimar Constitution did not do a good job of securing the basic rights, because it allowed Hitler to override basic rights. So then we move to the era of the Grundgesetz, which emerged from which was basically imposed on the Germans with some help of the Germans themselves in the Allied occupied territories, and then under the West German government, and this is where the Freiburg connection is very important. So in Germany, already during the Weimar times, there was a movement of legal scholars and economists, which later became known as the Freiburg School or the Otto School of Law and Economics or Political Economy. And in fact, they were constitutional political economists who were liberals, and they were Otto liberals. So they were kind of a German version of this liberal egalitarian thinking. And they wrote against what they saw as the rising threat of fascism very fiercely. And in fact, several of them got into trouble for doing that. But as a result, at the end of the Second World War, their influence was quite prominent, especially under the governments of Konrad Adenauer and the economic ministry of Ludwig Erhard. And Erhard in particular was directly influenced by the Otto scholars and associated scholars who were writing about the constitutional dimension of political economy. So, so the Otto school emphasized order, as the name implies, very German thing to emphasize, I suppose. But there was a liberal order. It was a liberal order that they emphasized. And what they meant by that is a set of basic rules between free and equal citizens that limit government discretionary power and also secure the basic rights of citizens. So let me just state the names of some of these people. So there's Walter Eucken and Franz Böhm are two of the most important early Otto scholars from here in Freiburg. Franz Böhm from legal scholarship and Walter Eucken from economic scholarship. But they combined their forces in the same faculty of law and economics, or economics and law. And they wrote a manifesto in 1937 called the Otto Manifesto, which really summarized their position. And they also wrote various important papers on the topic. And one of their key concepts is the economic constitution. What did they mean by the economic constitution? The economic constitution, or the Wirtschaftsverfassung, is a term they used for, what later people like Rawls would call the basic structure. It's the economic constitution is that set of institutional rules which act as institutional safeguards of, in particular, property rights, freedom, and stability of the social order. And they emphasize that what you need is a security of these rights in order to have a well-functioning social order. Compared to some of the more laissez-faire liberals of, for example, the English tradition, they also, especially later on, with people like Alfred Müller-Armack, emphasized the social dimension, and that's where the phrase social market economy comes from. The social market economy, Sozialmarktwirtschaft, is which actually kind of became one of the sort of official slogans of the early West German government coalitions, was that you need to have the basic rules of economic freedom, but also supplement them with various forms of constitutional protections against the concentration of private economic power in the form of monopolies, oligopolies, and cartels. They had seen that the cartels were running over the German economy after Bismarck's time, and they wanted to prevent that, and they also wanted to prevent the threat of fascism, but also communism. And so, therefore, the economic constitution guaranteed basic rights and freedoms, but also it guaranteed some amount of social welfare provisions. But the economic constitution was not a written document. It was a very abstract level of theorizing, and in fact, some scholars have recently argued that one of the biggest mistakes of the Otto School was that they did not take the social dimension of the constitution seriously enough, and they were not explicit enough in writing what would it mean to have an Otto constitutional approach to social welfare. Therefore, you find almost all of them arguing that some level of redistribution, income redistribution, is justified by the economic constitution, but what this means in practice was not specified. And this is where you see the problem again. The constitution can be very abstract and vague, or it can be very concrete and specific. If the constitutional provisions are very abstract and vague, then people can fill in that vagueness with their own interpretations and models, and this is precisely what happened in the decades following the West German constitutional model. So yes, you had very strong constitutional provisions against monopolies. Yes, you had very strong constitutional protection of competition, but what kind of pension system should there be? What kind of unemployment insurance there should be? These were all decided rather ad hoc on top of this constitutional structure. So Germans should really think about what does this constitutional history mean for us today? It does, if we want to maintain some parts of that sort of ordo-liberal approach to constitutional structure, should we go more specifically into thinking about the constitutional dimension of the social welfare provisions and social security provisions, or should we have this more of an ad hoc kind of patchwork approach where we have kind of few basic rights, but we don't specify exactly what kind of welfare state or welfare structure we want, and how basic income fits or does not fit into these kind of structures. And in fact, let me now read you what the German constitution now says. And then I will compare that with what some of the other constitutions say on this issue. So the German constitution has the following provisions. These are pretty much the old provisions that have to do with social security. So for example, Article 6 is about marriage and family. Now this is a very interesting way of putting it. So one of the phrases, marriage and family shall enjoy special protection from the state. And the care and upbringing of children is the natural right of parents, but the state shall watch over them. The state shall watch over families and the upbringing of their children. This has been used to justify support for families. Here's also one interesting addendum to this, which is every mother shall be entitled to the protection and care of the community. Okay, so if you have a clause that says every mother shall be entitled to the protection and care of the community, what does this mean? First of all, does it mean that fathers are not entitled to support? Because fathers are not listed. Does it mean for every mother to be entitled to protection? Does it mean that they need to get support for raising their family? Does it also mean they need to get basic income? That's a plausible interpretation strategy, but it's not obvious at all what it means for mothers and families and children to be protected. And then you have, very vague clauses elsewhere, like public welfare. The state is responsible for public welfare. Okay, what does public welfare mean? Well, then we can debate forever what that means. And then under labor law, specifically under labor law, you have guarantees of occupational health and safety and social security. So this is where social security is listed under labor law. Now, what are the consequences of having social security under labor law? You can think about what that means. Is it good for it to be under labor law? Does it mean that social security has to be tied to labor? And the specification of unemployment insurance as the paradigmatic form of social security. What does this mean for basic income? And compare this, for example, with the Finnish constitution. I'll speak for about 10 more minutes or so, and then we'll stop. In the Finnish constitution, we have much more carefully specified, detailed provisions of social security. We have section 19 of the Finnish constitution. It's all about the right to social security. So it is very long, and you can read the English translation for yourself if you want, but I'll just pick up a few things from it. So it guarantees every citizen the right to basic subsistence in the event of unemployment, illness, and disability, and during old age, as well as the birth of a child or the loss of a provider. The public authorities shall guarantee adequate social, health, and medical services and promote the health of the population. And the public shall also support families and others responsible for providing the children, very similar to the German case. And there's also a right to housing. So citizens also have a right to housing. So this is a very broad and very detailed description of the right to social security. Note, nowhere does it say people have the right to basic income, but people have argued that this can be used as a justification for basic income, and other people say no, it only justifies conditional benefits for these specific purposes, unemployment, disability, old age, and so on. Okay. Now, one more comparison, the US Constitution. The US Constitution has nothing on social security, has no protection against unemployment, against old age. In fact, it only has this very vague notion of general welfare. So there's this famous general welfare provision which does not specify anything. So therefore, 2.5 centuries of US constitutional scholarship have argued about, does the public welfare clause justify extending the welfare state, extending kind of New Deal structures, extending even basic income. It's very vague, and this is where conservative and progressive and liberal people debate around what it means. I will also briefly mention, in session 2, I will go more into the human rights level, but I should also emphasize that rights are today not only protected in national constitutions, but also by international human rights law, to which most countries, certainly all Western countries, are signatories to most of these clauses. So you have the UN Declaration of Human Rights of 48, which guarantees everybody the economic, social, and cultural rights indispensable for dignity and free development of personality. And then in 1966, you have the UN International Covenant on Economic, Social, and Cultural Rights, which recognizes the right of everyone to social security, including social insurance. So they specify social security and social insurance. What does this mean? Conditional benefits, unemployment benefits, pensions, basic income, maybe, maybe not. But it's important to recognize that national governments are bound by their international human rights commitments, so they are also bound by the declaration of the right of everyone to social security, including social insurance. So very briefly then, to conclude this session, I will argue that from the Otto perspective, and I'm just saying Otto as one particular plausible research program, if you want to pursue that. Even if you don't, you can have a constitutional approach that comes from a different perspective, different ideological perspective, because you can have a plurality of constitutional approaches to basic income. You can have this kind of a more liberal approach which focuses on freedoms and rights, or you can have, say, a more kind of progressive constitution which focuses on kind of the positive rights to various benefits and welfare state structures. You can think of different ways of building a constitutional approach to basic income if you want. But from the Otto perspective, there's a calling, because scholars have argued that one of the biggest mistakes of the Otto school was precisely the lack of clarity on what the Otto approach, constitutional approach to basic income should be. And for example, Müller-Armack, who's one of the most important thinkers and indeed a politician, wrote very vaguely about what the social market economy says. He wrote that the idea of social market economy is not restricted merely to making the instruments of competition capable of functioning according to social interest. Income creation in the free market system provides a solid basis for the redistribution of income by the state. Income redistribution is brought about through welfare benefits, equalization of pensions and compensation payments, housing grants, subsidies, etc. And then what does the etc. mean? And he emphasizes that to disregard the redistribution would be to fail to appreciate the social context of the social market economy. Now, I should emphasize that not all Otto scholars are so explicit in their support for social insurance, like Wilhelm Röpke is much more critical. But again, there is room there for thinking about basic income from a constitutional point of view. And so the paper that you have read comes from the American point of view. It is an example of a constitutional political economy perspective from what is called the Virginia School of Political Economy. And in Buchanan's case, there are many similarities to what I've discussed today. It is explicitly influenced by centuries of Enlightenment social contract thinking of the constitutional matters, and it puts a specific spin on it from a kind of market liberal point of view. And it emphasizes that so according to Buchanan, which you can agree or disagree with, one of the problems of the welfare state, that it gives too much room for discretionary action in the sense of instability of the welfare state structure. So you have governments continually arguing and debating about, which group of people should get money, and oftentimes it ends up into a rent-seeking competition where one group of people, say the farmers, are fighting for higher levels of farm subsidies. The business world is vying for higher business subsidies. Workers are vying for higher unemployment benefits and worker compensation, and people without work are vying for higher levels of basic social assistance. But what this means is that there is no regard for these kind of foundational questions of, should we have a system that is working for everybody? Can we have a social insurance system that is more geared towards general interests and principles rather than special interests and this kind of discretionary rent seeking? And if so, could basic income be a part of that? So Buchanan does not advocate for basic income, it should be emphasized. He has created a theoretical model of, if you want to have a redistributive system, here is one theoretical constitutional model of how you can go about doing that by tying the rules of redistribution directly to the constitutional structure of the state. So the two takeaways from Buchanan's approach are that can we think about basic income not as something that is a policy given by a discretionary benevolent government, like an electoral promise of a populist leader, for example, but more as something that we all decide with strong support from the different sectors. If we can find some way of finding common rules that bind us all, again, this is what the Constitution is about finding common rules that bind us all. And therefore having both the transfer system and, crucially in his case, also the tax system as part of those basic rules. So the Constitution is not there to say we should have a high level of basic income. It's not there to say we should have a low level of basic income. It's there for Buchanan to say, here are the rules by which the parliaments can decide on what kind of basic income they want. So it specifies the form of basic income, and it does not specify the content. So this constitutional perspective is what the paper is about, and the important thing here to realize is that since, for example, the Otto scholars never specified concrete models, it behooves us to look at more concrete models like Buchanan's to say, does this fit into this perspective? Does it fit into other perspectives? And the other plausible models. So for example, I have skipped in my paper discussion of roles, except briefly mentioning the basic structure, but Rawlsian approach to constitutional governance would also could also be used to think about what the foundations of the basic rules should be. In fact, there are lots of similarities between Rawls's approach and Buchanan's approach. But I think I've already spoken a little bit too much. I think it's time for me to conclude by saying that what is this all about? Well, it's all about how much should we rely on the constitutional structure versus the parliamentary structure of ordinary politics to decide on basic income? How much should we rely on fixed rules that bind all people and also all policymakers? For example, that basic income is set in stone, but then people can argue about maybe lowering it or higher, setting it at a higher level, but not abolishing it, at least not without a constitutional amendment. And how much should we focus on kind of basic income from the point of view of basic rights and the equality between citizens, and how much should we use it to advance certain policy targets like solving unemployment? If we use basic income to solve unemployment, we can forget about the right stuff. It's not important. We only care about unemployment, and this is what a lot of these experiments, for example, have been all about. But if we take the constitutional structure seriously, if we take the right structure seriously, then we should think hard of what this means for basic income governance going forward. And with that, I will stop. So thank you very much. And now I think we can have a 5-minute coffee, stretch your legs break. So let's start again after 20.